Welcome. Thank you all for joining us. My name is Miriam Feldblum, and I'm the President and CEO of the President's Alliance on Higher Education and Immigration, a group of close to 600 college and university leaders of public and private institutions from around the country that have come together around the immigration issues that impact our students, campuses, communities, and nation. Today, I'm thrilled and grateful to be joined by partners from NAFSA, Fragaman, the Institute for Progress and Cornell Law School, and the University of Rochester. The United States thrives when we attract, educate, and retain both domestic and international talent. Now more than ever, colleges and universities need to come together to support the academic success, access, and post-graduation pathways for international, immigrant, and refugee students and graduates. Our goals today are threefold. First, it is to explain the key provisions of the Department of Homeland Security proposed rule to end duration of status for F1 students and J1 exchange visitors, what it means and why it matters. Our speakers will discuss its potential impacts on international students, scholars, institutions, research, and local economies. You'll hear from legal and policy experts as well as the campus perspective. Second, we aim to put this proposed rule by the administration targeting international students and campuses in context. This proposed rule is one of a series of harmful administrative actions that continue to undercut the stability of international students and scholars already in the U.S. and aims to deter and adversely impact the prospects of international students seeking to come study here. The consequences, chilling effects, and contours of these actions are coming more sharply into focus every day. This fall, many campuses are seeing declines in international student enrollment. Surveys show a turning away from the U.S., and administrative actions such as this one continue to generate anxiety and uncertainty for current and prospective students and scholars. So the third goal is our call to action. We'll share with you resources, guidance, and tips so that you can engage and respond effectively, both through the public comment period that's open till September 29th and other advocacy actions. What can you do now and how to do it? Over 8,000 comments have already been posted on the proposed rule. And we need your and your institution's comment too. We and our partners have new resources, tools, and ideas, and I hope you will join us in action. As you hear from the speakers, think about what you can do now. This is the time for individual engagement and collective action, and you'll hear options and opportunities from the speakers. Let me end my part with a few logistics and thanks. This webinar will be recorded, posted, and shared with all registrants. We'll be putting resources and links in the chat. This includes the slide deck and speaker bios. They'll also be shared in the post-briefing email. Importantly, put your questions in the Q&A box, not the chat. And thanks so much to our colleagues, Corinne Kenter and Caitlin Johnson, for supporting this webinar and managing the chat, Q&A, and resources. Now, I'm thrilled to turn to my colleague, Susanna Sipla-Woodson, who will introduce our speakers and moderate the remainder of this briefing. Over to you, Susanna.
Thank you so much, Miriam. Hello, everyone. Thank you for joining us today for this important conversation. We have some great speakers with us today. We have Heather Stewart, Counsel and Director of Immigration Policy at NAFSA, who will start us off with a summary of the proposed rule and some high-level guidance on what to include in your comments. Amy Nice, who is the Distinguished Immigration Counsel and at the Institute for Progress, an Immigration Law and Policy Fellow at Cornell Law. She will further elaborate on what to include in your comments and outline some possible next steps in the process that we can expect following the ongoing comment period. Then we will have Sarah Peterson, a managing partner at Fragaman, who will discuss possible implications of the proposed rule for the impacted students, but also universities. And last, but definitely not least, we have Ravi Shankar, the interim Vice Provost for Global Engagement at the Office for Global Engagement at the University of Rochester, who will provide us with a campus perspective and share some examples of what they are seeing as key points to highlight in the comments. So as you can see, we have a lot to cover. You can read more about our speakers in the document that we just shared in the chat. But now, without further ado, let me give the virtual floor to Heather, who will kick us off.
Thank you so much, and thank you for all of you here today. What I plan to cover in my portion of this discussion is a review of key provisions that are in the proposed rule and actions you can take in response to the proposed rule. The proposed rule is over 160 pages long, so I'll be doing a bit of a flyover, but I think we will cover a lot of material today among all of us speakers today. Please use the reference material provided during this webinar and elsewhere to build your understanding of the contents of the proposed rule and to understand the wide-ranging impacts of this rule if it were to become final. So what does the proposed rule do? The proposed rule attempts to require a fixed period of admission for all Fs, Js, and the rule also applies to reporters entering on I status, but we're not going to focus on reporters today. It's quite confusing for some people outside of the field to understand how the process works. The right now duration of status when someone who is seeking to enter on F status or J status arrives at the port of entry, the port of entry officer, the CBP officer, provides them with duration of status or D/S. And as you know, that means when you're in the United States, as long as you're complying with the requirements of that status, you are good. You are maintaining your immigration status, if you're making normal progress towards completing your academic or research objective, or if you're engaging in optional practical training. The proposed rule changes impacts international education from the beginning of English language programs through the postdoctoral student and everyone in between. And it's not just the programs themselves, but it's that pipeline issue that throughout education and beyond, from students thinking of studying here and through the process to whether or not they want to remain here to work for a longer period of time. So how will the fixed period of admission be determined? So at the port of entry, as I mentioned, CBP officer is in charge of determining how long a non-immigrant may remain legally in the country if admitted. And under this proposal, Fs and Js and their dependents would no longer get DS. The port of entry officer would look at the form I-20 for the DS-29 and then determine the admission period based on the end date of the program or area of the length of study, or a maximum of 4 years, whichever is shorter. And the expiration date would be recorded on the form I-94. So Fs and Js who need more time than is provided at the port of entry would be required to file for an extension. And that would require filing with the U.S. Citizenship and Immigration Services, the I-539 extension form, and pay a fee, provide biometrics, possibly do an interview. And this would have to be done before the period of admission expires. And who will be required to file an extension of status is quite extensive and probably surprising. It's not just people who need more than 4 years or to complete their program of study. The extension of status would be required if your program was extended, if you transfer schools, you start a new program, if you move up an academic level, say from undergrad to graduate, and to use post-completion practical training or do academic training. So for someone that enters for, say, a 10-week English language program, if they decide that they want to continue to the next program in their English language study, they'd have to file for an extension of status. If you have a PhD program that lasts more than 4 years, it will require the filing of an extension of status. In J1, doctors exchange programs that can last now up to a maximum of 7 years, I believe. An extension of status would be required beyond 4 years. And you see that this would require some students and scholars to file repeatedly for extensions of status. And this would be with USCIS, as I mentioned, and that's an agency that regularly experiences tremendous backlogs and processing delays. And this would be a great burden for students and exchange visitors and their families. And you must remember that filing for an extension of status, USCIS has discretion in the adjudication. The rule provides some criteria for review. However, the process inserts a level of uncertainty for those seeking to study in the United States and for those who are already studying here. The USCIS can deny a student or exchange visitor application for extension of stay, and they must say why they are denying it if they do, but they could say if somebody is not making normal progress, if they don't feel like the person is making normal progress, if they can't prove that they have the ability to pay. And then there are these reviews that are now being done for your online presence, your social media posts. And so that process is a bit of a black box. So in it being new for international students and exchange visitors, there's a lot of uncertainty there of how that would work. And there are some key restrictions too in the rule at various levels of study and programs. So English language trainings, students are limited to a maximum of 24 months. That has a direct impact on how those programs may be administered. It also has an impact on their study. If they complete an English language training program and they seek to go on to a community college or seek other degrees, they would have to file for extensions of status. It severely restricts students' ability to change their degree programs. Students below the graduate level would be locked into their initial institution and program for at least 1 academic year, unless SAVP authorizes an exception for extenuating circumstances. We do not know how liberal they would be with that interpretation. Graduate students, by contrast, would be completely barred from transferring or changing programs. There's also a prohibition on lateral or reverse matriculation. So it bars international students from pursuing a program in the same or a lower education level. It looks at vertical matriculation only. Now, there have been questions about international students who are seeking PhDs, and if for some reason they are not able to complete that PhD and they would opt to get a master's degree instead, this rule does not make any statement about that. It seems as though that would be going down a level, which is not allowed by the proposed rule. Then there are also negative implications for options after graduation, both for access to OPT and then longer term employment. As the rule is written, it's likely that post-completion OPT will require a filing of an extension of status with USCIS. The rule does not provide insight into how USCIS will consider these extensions of status and for either the initial 1 year of OPT or the 2 additional years for STEM OPT. And extensions of status are discretionary. There's no assurance that USCIS will regularly extend status for people seeking OPT. We know that the Trump administration has officials that are not fans of optional practical training. The most recent publication of the regulatory agenda for the federal agencies indicate that OPT is on the list of upcoming regulatory actions, and that assuredly will at least greatly curtail access to OPT. And beyond OPT, we know that the Trump administration has plans to propose reforms to the H-1B program in ways that will make it difficult for recent graduates to get H-1Bs. This is an issue that I'm sure Amy Nice will discuss further. So with all that, what can you do? Encourage your institutions or programs to submit a comment letter. NAFSA worked closely with a group of higher education associations, including the President's Alliance, to provide guidance for institutions to submit comments on the DHS proposed rule to end duration of status. I know our colleagues will put that link in the chat box, sorry. And the goal is to provide data and statistics that are unique to your institutions. This will help advance the cause against the rule and also helps with potential future lawsuits. You may also use the results of a survey on international talent pipelines that NAFSA has helped along with the Institute for Progress with Amy Nice. The survey looks to current and prospective international students and what impacts their choice in studying in the United States. And it asks questions about access, and if duration of status were to go away, how would that impact their desire to study in the United States? Gathering information about your institution will really help you understand the reality on your campuses and in your programs. If this rule were to become final, it would be helpful to know how many extensions of status filings you can anticipate every year, how many PhD programs are more than 4 years, dual degree programs, non-traditional programs that you might have, and how the limitations built into the proposed rule will uniquely impact your institution. And after all of that, what can you do? You can also advocate with Congress. NAFSA partnered with the US for Success Coalition in a campaign to urge representatives and senators to weigh in with DHS to oppose the DS proposed rule. The US needs a system that works to continue to attract talented international students and exchange visitors, and this rule will only stand in the way of that. Please add your voice to the campaign with outreach to your senators and representatives. Your voice matters. Providing information about how this proposed rule will uniquely impact your institution. If you can comment yourself, how it will impact you, your community, all of that is very helpful within a comment letter, with communication with members of Congress. And so thank you very much. With that, I will turn it over to Amy.
Thank you, Heather. Heather had a lot to cover. I'm going to try my best to be focused on a particular question, which is, what can you do now? One part of Heather's introduction. We're in a moment where our government is now treating and considering some things we all thought were self-evident truths as contested propositions. One of them apparently is the value of international students in the United States of America. So I want to talk today about what you can do to preserve the value of international students, scholars, and researchers coming to U.S. college and university campuses. On the one hand, it sounds innocuous for the Department of Homeland Security to announce that it wants to exercise agency oversight, enforce U.S. immigration law, protect the integrity of the F1 and J1 visa categories, promptly detect national security concerns. That is their job. But preserving our ability to attract international talent, as Miriam said in her introduction, is something we should all maybe consider to be our job as we're assessing what to do about the elimination of duration of status admissions for F1 and J1 visa holders. When I worked at the White House, I was really surprised how often people spent their time admiring the complexity of problems, but not taking action to do something about them. And a corollary, admiring the authority of others to act and take care of problems. Do not presume that the 8,000 comments Miriam referred to that are on the record now are useful and substantive and share the types of specifics that are needed. So part of my role today, maybe self-appointed, is to say we the people, can do something about eliminating duration of status. What is it? What can we do? When there are policies that federal departments and agencies cannot change without writing a new regulation, then departments and agencies must comply with the Administrative Procedure Act. No pronouncement from the Oval Office can eliminate duration of status. Only notice and comment rulemaking can do the trick. Now, to be sure, this is not a huge hurdle. If a department or agency has a real problem they want to solve and has thought through what they think is the best way to do it. First, maybe this is a side note, but it's important to understand. There is no question that DHS has the legal authority to change all F1 and J1 admissions from duration of status to fixed periods of admission with extensions of stay on back end to be adjudicated by DHS. It is not per se illegal. It is not unconstitutional. It is not a violation of the Immigration and Nationality Act. It is not being promulgated by a Secretary of Homeland Security who is not properly appointed. It's not an interim final rule process being abused. But under the Administrative Procedure Act, DHS cannot change to fixed periods of admission instead of duration of status without first recognizing the actual costs of how it would do so. How is it going to administer this new approach and how much does it cost? Second, properly weighing the risks associated with its new approach. And third, adopting the least intrusive and cumbersome alternative in implementing the new approach. Under the Administrative Procedure Act, though, a legal court challenge to a rulemaking cannot succeed unless the administrative record of the rulemaking contains evidence that costs were not calculated correctly by the agency, that the agency did not fully or fairly consider risks, and or that workable, more predictable alternatives were rejected. No plaintiff can come to court later and say, the duration of status elimination rule doesn't comply with the APA because the cost to America is 10 times what the agency calculated, or the agency didn't consider costs to institutions like mine, or J1 programs like mine, unless there are comments in the record saying this. So let me give you some examples of where DHS has invited your comments in its formal notice of proposed rulemaking in the Federal Register. These are 5 points. They're not exhaustive. They're not the only ones you can comment on, but they're worth considering, worth starting to think about. First, DHS repeatedly says that it believes the costs to schools and J1 exchange visitor programs will be, quote, incremental. If you can quantify the costs your organization will incur, this would be important. If you can't share the exact figures, make the calculation and then share the percentage changes. That could also work. Second, DHS says that it welcomes comments on costs, including data and information that could support quantification, as well as proposed alternatives to reduce burdens and impacts. This might sound like the same thing as challenging that costs are not just incremental, but let me tell you how it's different. Here, DHS is making clear that you can provide a lot of value, not just in comparing the costs, are they incremental or not, but explaining how the costs add up to your institution or program. Detail how you currently monitor F1 and J1 students, scholars, and participants, and how specifically that would have to change. Whether more different types of staff would need to be involved. How exactly do you do what you do now? How exactly would you have to change that? And importantly, put on your thinking cap and propose changes. I can assure you that no one at DHS or in this administration has their thinking cap on to develop a less cumbersome way to do this. Third, DHS specifically talks about how 79% of Fs and Js have programs that conclude in less than 4 years, so their fixed period of stay approach really only impacts a few people. Talk to your programs that do, by definition, last longer than 4 years. Thinking about all PhD programs in America, J1 physician programs for residencies, J1 K through 12 teacher programs, postdoctoral fellowships. These may be a smaller contingent than Fs and Js in degree granting bachelor's and master's programs, but they may be some of the most valuable to the nation. Fourth, DHS states unequivocally that impacts to international student enrollment and exchange visitor participation will be minimal or marginal. As Heather mentioned, and I just want to flag again in this context of making comments, in anticipation of this rulemaking, NAFSA undertook 2 surveys, a survey of current graduate students and postdocs, which ran from August 22nd to September 12th, that the National Postdoc Association and the Science Societies, led by the American Physical Society, distributed, and a survey of prospective students outside the US that was distributed between August 13th and September 12th by 3 organizations that recruit international students. The key survey results and all the tabulated results as well are public, and the President's Alliance already shared that link with you. And you should use these to counter the notion that we can reasonably expect there to be minimal reaction to the elimination of duration of status, especially by PhDs and postdocs who in the current grad student and postdoc survey reported specifically with regard to the duration of status rule that 49% would not have come to the US if duration of status was not in place. Makes sense because they would be going to the United States without knowing they could complete their program. Fifth, DHS specifically invites comments about the extension of stay process that they are creating. This is more technical and in the weeds. I'm sure the President's Alliance, ADAFS, and others are developing comments on issues with the extension of stay process that they've proposed. But one thing you can do, in addition to providing your input and thoughts to others who are going to be making those sorts of technical comments, is to look at your own institution and your own programs about how many of your students at all degree levels request OPT, because 100% of them will have to do an extension of stay adjudicated by USCIS. How many PhDs do you have? Because 100% of them will have to do an extension of stay adjudicated by USCIS. And today, none of those students need to do so. If you run a program a J program that is longer than the initial period of authorization that you're able to give, the initial validity that you're permitted to issue a certificate of eligibility for, or by definition is going to be longer than 4 years, how many of those individuals, how will that affect will be affected, how that affect your organization? If your responsible officers or designated school officials do have ideas on how to fix the extension of stay process, that Sarah Peterson, who's up next, will discuss, you should put that in a comment that goes into the administrative record, or share those thoughts if those are things that you feel you can't comment on with others who can make those proposals and suggestions. Let me leave you with another reason why you should take action and write comments on one or more of those 5 points. I would tell you the nation needs you. In the National Security Innovation Base, foreign-born experts comprise 37% of the workforce with advanced STEM degrees who are working on DoD-funded projects. In the last 25 years, since the year 2000, the share of foreign-born professionals working in the US across all strategic industries has increased from about a quarter, 26%, to over 1/3, 36%. Almost all of these individuals first came to the United States as students, scholars, and researchers at our colleges and universities. How do we know? The National Academies was asked by Congress through the National Defense Authorization Act to study America's international talent programs. After 15 months of review, an August 2024 National Academies report concluded, in essence, that the primary, if not sole, global talent pipeline for the United States is the international students, scholars, and researchers attracted to US university campuses. Quote, the United States has a talent program, the National Academies Committee Chair said. It's called graduate school. So by happenstance, the US has a leg up on every country in the world because of you, our higher ed community of institutions, In order to rely on the magnet of our nation's universities for our workforce and for our economy, that pipeline that Heather mentioned, we need your comments. I'm trying to do my part. I'm going to do two things that I want to share with you before I close, because they might relate to what your institution does with regard to comments. I've been working over the last several months with the economist Michael Clemens, along with my colleague at the Institute for Progress, Jeremy Neufeld, to analyze 20 years of data we received by FOIA to analyze what we're calling the front door STEM talent pipeline of F1 students, the same pipeline that Heather mentioned in her remarks. Our nation's STEM workforce and U.S. economy will suffer tremendously without F1 students. We're trying very hard to have a working paper published by September 29th so that we can include in the administrative record of this duration of status rule the report and detailed analysis and methodology. As Miriam said, this is one of a series of rules that we think are coming, where we think this analysis of the front door pipeline and the impact will be very important, but we hope to get it in for this duration of status rule. Some people talk about brain drain and now like to refer to brain gain, but in our paper, we basically talk about a brain freeze if international students, scholars, and research are deterred from coming to the US. In the meantime, I've drafted a comment for Michael to file with DHS on the DS rule that is shorter than our 40-page paper, that summarizes in a few pages our findings on cost. We'll share that with you as soon as it's filed. You can cite to that for national level cost estimates. In addition, I'm working on a sign-on comment to address two parts of the extension of state process. I hope that'll be out for your consideration in a few days. It's going to be a very short turnaround that should not in any way replace comments that you do specifically about the impact to you and your organization, but it's something else to consider as far as specific tailored solutions. So my advice today is, please do not just admire the complexity of this problem. Please do something about it. Now I'm going to hand it over to Sarah Peterson to tell you the real details of what's in the proposed rule.
Thank you so much. Thank you so much, Amy and Heather. I know that Sarah will take us to the next section of the webinar in a second, but I just thought it would be really good to sort of build onto what Heather and Amy just shared with you all. And it was, of course, so much information. And, I would just underline one more time what Amy just said about the need to comment. To do that, I just wanted to stress that the President's Alliance worked together with NAFSA and other higher ed partners on a high-level guidance that both Amy and Heather referenced. And we also developed a separate companion document with additional talking points to support campuses, organizations, and individuals as they draft their individual comments. So the link should now be in the chat, and we will share it also in a follow-up email. And you will see that the President's Alliance's resource also includes some links to other resources that you can use as you're drafting your comments, including the NAFSA Economic Value Tool and Global Detroit's new website with some great data about local impact and impact on the private sector. So both these documents were created to give you as much guidance on drafting of your individual comments as possible. And I would like to also stress, though, that it is crucial that you customize your comments to make them unique to your organization. And one last thing I would like to say, many of you who join our webinars, often enough probably heard that the President's Alliance also has a survey opened. We are sort of gathering data on contributions of international students, and we already have some great results that we are just now analyzing. And we'll share with all of you soon. But I really wanted to underline how important it is to sort of put together your comments, build this record, show the contributions of international students and scholars, and stress how important they are for our communities and what a huge impact they have. And now Sarah will tell us more about how this proposed rule would impact international students and institutions if it was finalized. Thank you so much, Sarah. Please go ahead.
Great. Thank you, Susanna. So I have a very short period of time to really do the so what. And there was actually a really good question in the comment of, are we being alarmist here? Is this just another process? Amy mentioned it makes sense for the Immigration Service to have oversight over our immigration programs. But I'm going to try to break down why you really do need to comment. So when I was trying to think about a very simplistic way to really explain why this removing of the duration of status will have such a consequential negative impact on students in higher ed, all I could really come back to is that it just provides maximum flexibility to account for how life happens. These are young people in the most unpredictable early stages of their life. These are not people with employers who are managing the process for them. These are students who are in a new country with a new culture, with new systems, and they're really trying to maneuver an immigration system that is really difficult to understand and practically impossible at this day and age to maneuver. I've been practicing immigration law for 30 years, or not 30 years. DS has been around for 30 years. I've been practicing a little bit less than that, but that's the real reason we have this protection, because it provides not only the institutions the flexibility that they need to support their students and exchange visitors, but it also provides this opportunity for people who are coming to the United States, as long as they're maintaining status, as Heather went through, to really ensure that they are going through their programs in the systems that exist as they stand today. So I'm not going to read to you why students would need to file these extensions of status. Heather did a great job reviewing this already. But I want to talk about the practical implications of how our immigration system actually works. So if you consider that in 2023, the US had over 1.5 million F and M students, that's a lot. So just by the face of this new regulation, we are going to see a huge influx of extension of stay applications. You add your J1 exchange visitors and scale this up, we're talking about a huge increase of filings to the Immigration Service. Okay, so now we're under the Trump administration, their second term, and we've had our DOGE cuts, we've had early retirements, and we've had hiring freezes. That has had a catastrophic impact on USCIS's ability to really process its cases. And when we're talking about an agency that historically has had delays, we're seeing bigger delays, and that's only going to compound when we have this huge influx of extension of status. So assuredly, we're going to see training issues, we're going to see delays, we're going to see incorrect denials and rejections. And remember, if a student files, and I'm just talking about the F1s right now, I'll get to J's in a minute, but if a student files to extend their status and they make a mistake because it's a confusing form, maybe they don't send the right fee, they get the denial, they have to leave immediately. There's no grace period. And finally, the other thing to think about with our system is the Immigration Service, there's no one to call. There's no office to go to. You have a nameless, faceless agency, and a tiny little mistake has catastrophic consequences. Just last week, I spent over 5 hours on the phone trying to get a human simply to open a ticket for an incorrect denial that I was dealing with. Students don't have the time, the resources, the bandwidth. The impact is real. And then one of the things that I think about is that when the way that our system works is that we have something called premium processing. And really that's just the ability to pay more money so that the government will review your case within a shorter period of time. So we know that premium processing is going to be available for people trying to change their status to F1. However, what's unclear is whether premium processing will be applied to extensions of status. And if you look at USCIS's website right now today, it very clearly only says change of status to F1. So I think that's a big open question. And I think if we're talking about all these different iterations of people who have to file to extend their status, and if premium process case is not an option for these cases, you're going to have a really long processing time. And just to punctuate that, right now, it's taking over 3.5 months for any extension of status case at the agency. So again, when we're scaling it up to the numbers we're talking about, if this regulation goes through, that timeline is going to go through the roof. So again, this is the precise reason that the SEVP program was created after 9/11, to really have a reliable mechanism to really monitor these students. And just given how the USCIS agency works or doesn't work right now, this really does have serious impacts to these students. if we go to the next slide, one of the things that we really want to look at here are potential institutional harms. I think the biggest thing that we need to talk about is that DHS itself acknowledges that it's an estimated $93.3 million in cost in just the first year alone for institutional compliance, and just sort of figuring out training needs, advising challenges, everything that goes into that. And they also acknowledge that DSOs and ROs will have to spend approximately 67 hours to familiarize themselves with the rules. So I've spent not quite 67 hours going through the hundreds of pages of regulations, but it's real. And I don't have students coming to me with these really complicated life situations. And so you've got the operational cost that is really going to impact how your institution is able to function. Some other things that we need to talk about are, you can see delays in the ability of students to start their programs. If there are agency delays, which is going to take more resources from your team, I think we've all hit on the fact that you can expect lower international student enrollment overall because it's just more complicated and complex and it costs more. And then, research going abroad. And I want to turn to the J1 side of the house now with my remaining time and kind of look at, on our next slide, how does this impact our exchange visitors, who are here doing their various programs? We have 15 different J1 programs. There's really only 3 that have programs that go beyond this 4-year limit. We've got our professors and research scholars, our trainees, and our international medical graduates. I'm going to talk about IMGs in my final slide because they are, I think, in a world all unto themselves. But none of these programs have historically issued the DS-2019s for the entire duration of the programs. That's due to a lot of different things, like for your, is there a funding for the entire, 5-year term of a research scholar? There's contract issues. Do we have a contract for the entire duration? So it could very well be an annual extension of status exercise for these J1 exchange visitors who are in the system trying to complete their training programs. And if we go to the last slide, I want to end on international medical graduates. This is something that's near and dear to my heart. I've been working with international medical graduates my entire career, and there is a resource in the link that ECFMG just published yesterday that really gets to the heart of why international medical graduates should not be put pursuant to this new regulation. First of all, these international medical graduates go through probably one of the highest levels of vetting of any foreign national in the United States. They have the Department of State vetting when they're getting their visas abroad. They have Intel sponsorship that does its own vetting. They've got the DHS oversight of the program more generally. They've got ACGME oversight. So there's just so many hands that touch these international medical graduates. In addition, the United States is facing a physician shortage. We've been living with this shortage for as long as I've been practicing. And these international medical graduates comprise 25% of our physicians in the country. So when you look at the J1 program, there's nearly 17,000 IMGs training, and they're providing patient care. Yes, they're training under the direct supervision of a physician, but they're also providing direct patient care. The statistics show that they are in over 770 teaching hospitals across the entire United States and Puerto Rico. And so what you can look at, if IMGs have to subscribe to this no more than 4 years, you're going to have the same things you have with F1s, higher filing fees, the delays. Our healthcare training program runs from a July 1st to a June 30th cycle each year. There is assuredly going to be a disruption in patient care and program continuity. When I talked to my colleagues in ECFMG and ACGME, they really talk about the fact that, sure, you have a 3-year primary care residency program, so why does this impact it? And it's not that simple, because it gets back to the required flexibility to encompass what life has to throw, whether it's the visa processing delays abroad, the ability to sit for the boards, which is the ultimate end goal for any of these doctors who are training in the United States training programs. So it's not as simple as saying, well, there's a lot of different residency programs that could probably fly under the radar with this new proposed regs. It's just simply not true. So, with that, I'm going to turn it over to the next speaker, and happy to take questions.
Thank you so much, Sarah. And yes, please, I see questions keep coming. If we don't answer to everyone, we'll do our best to follow up and answer following our webinar. But now we have Ravi Shankar, who will conclude the panel portion of our webinar and share more about what the University of Rochester is planning to do and how they will approach their comments. So Ravi, please go ahead.
Thank you. Thank you, Amy and Sarah. One of the personal story that I wanted to share is that when I came as an international graduate student, I came under a date certain program, right? And I've personally experienced the the problems that you have to go through. But in those days, you really could go to the regional service center and get a program extension. You could actually go to St. Albans, walk in, and get a program extension approved right away. So I think things have really become more complicated than in the early 80s. But with that said, I think, what I'm really going to focus on really is not the specifics of what they propose at the NPRM really state, because I think that's been really exhaustively covered by Heather, Amy, and Sarah. But I wanted to sort of cover more broad areas when considering, how, what do you include? But before that, what are the preparations that you need to do? Can I have the next slide, please? So, I think, and you may have already done this, and, I'm certainly preaching to the choir, but I thought it would be a good, I think, to recap, if you're still in the process of gathering these comments and data, is, who are your stakeholders that need to be involved? Of course, legal counsel, government relations, the registrar's office, academic divisions, academic advisors, who are all the players in terms of, because this NPRM, I think, really touches upon every aspect of your institutional administration, and everyone touches international students in one way or the other. So I think it might be important to really get all the stakeholders together so there is some collective buy-in. And I think the comments or the job of writing the comments are probably shared across divisions, and doesn't necessarily have to be the work of the International Student and Scholar Services Office, and because you certainly need other players in terms of data. Also, how does this proposed rule, and I think Amy made this point very, very succinctly, is that you have to be very specific in terms of how is this impacting your institution that is unique to you. And the HSS say that they're looking for such comments. For example, at the University of Rochester, we are the largest employer in the Western New York region. So this is a tremendous area of economic growth. There's financial impact to this NPRM if this goes through. And then, then of course, you have to consider, who will sign the comment letter. Is it the senior international officer? Is it the provost? Is it the government relations people? So I think those are some of the preparatory things that we thought about and discussed before we actually even launched into the commenting period of this. And lastly, I think I'm just going to reiterate what NASA has said in terms of you can submit these comments online directly, but it has a 5,000 characters, but I think NASA recommends that you do a searchable PDF file upload. Can I have the next slide, please? So from a campus perspective, again, this is really broad strokes, and all of you have actually thought about this, but I'm just going to voice some of the things that I think that have already been stated earlier, and some of the things that you've been discussing internally, of course, is the proposed fixed period is problematic for all the reasons that have been cited, and particularly I think in the case of because you have unique programs. And you have dual degree programs, you have interdisciplinary programs, you have joint degree programs, and all of these things I think serve as a barrier because it's not entirely clear. Because if the students you will have to apply for program extensions each time they complete something. I think later on, I think has been said, and it's the last point on this slide is what is the economic impact to our students? So what kind of data have you gathered in terms of time to completion? How many program extensions have you done? How many OPTs have you done? I think this has been also covered by Amy and Sarah both, and Heather as well. For example, the University of Rochester, when we did a 3-year benchmark to program extensions, just taking a slice of example for doctoral students, I think 80% of them were program extensions, right? So this is a huge number. So there's, as you will see later on, what is the consequences and what is the impact to the operations of the office in terms of staffing and the cost. And has been mentioned, life happens. And so if program extensions can only be given for academic reasons, then, how do you deal with, students who take leave of absences, students who are suspended, students who are on probation, and so on. So I think we'd have to really consider how internally we're going to be dealing with this, and what is the educational programs that I think we're going to deliver. Graduate students not being able to change programs, we've already covered this. We've already covered the bar on reverse matriculation, particularly, I think to the earlier point, if PhD students decide that this program that they're in is not suitable and do not intend to continue with the PhD program, can they just stop at a master's, because that's a different level of program. So I think, have you discussed this with your academic, administration, people who deal with, your state board certifications and those kinds of things. And if you don't have specific data, I've plugged in here for NAFSA is recommending including data from the National Center for Education Statistics and also the NSF data, which cites a median of 5.7 years for PhD students to complete their programs. And so I already touched upon the economic impact to students and visitors. What does it mean for filing fees, right? Particularly for those students who are on financial aid, for example, institutional financial aid, do you have to recalibrate financial aid, or is the institution going to cover these costs, for really, high need students? And I think those are some of the things that I think we were already been discussing and talking about. Next slide, please. So the other thing that we were also talking about is, this is very obvious, the proposed rule is unnecessary and then intrudes into academic decision making. And the ability of students to make appropriate decisions based on their circumstances, right? Or based on their academic advisors, based on their faculty advisors. Why does USCIS need to be involved in this? Are they really equipped to handle, and making decisions based on academic reasons? Are they, how obviously, they're not very familiar with any of the academic programs, because otherwise they would not have proposed a 4-year rule, because they obviously forgot that there's a such thing as graduate education. And the emphasis on the decisions on academic progress is best left to institutions and to faculty and academic advisors, as they are the experts. And, PDSOs and DSOs make recommendations for program extensions, as within the framework of the regulations, and I'll finish up very quickly here. It's not as if we're making arbitrary and capricious decisions and just recommending program extensions. And so I've already made the point of the USCIS officers not equipped, and then we can go to the next slide. And I'll skip most of this because the value proposition of international students and EVs that what they bring to the campus. And finally, I think one of the things that we really need to emphasize here is that the DHS already has a system which is CBIS, right? And they can actually cover, and they can track because of our reporting requirements. And if, they already require us to keep up backup documentations every time we do program extensions. So that is something that we can easily provide to them if should they need additional documentations. And the last, I won't cover the last one because it's already been covered, in terms of how this may impact the US leadership in competitiveness in critical fields. But I think lastly, I just want to really touch upon, what are the legal liabilities for us in terms of advising students for program extensions, because we can't really provide legal advice. So, would your institutions redirect them to attorneys? And if so, what is the cost? What is the structure? What is the governance around this? Who's going to cover the cost? I think that those are some of the things that probably we need to keep in mind as we are, not only discussing the comments, but also how do we support international students? How do we support our own scholars? How do we support our staff? Which obviously with escalating, workload, that is probably due to come. So with that, I'm going to stop, and thank you, and I'll be happy to answer any questions.
Thank you so much, Ravi. We really appreciate it. Thank you for sharing with us. And thank you to all our speakers. Please, if you could now turn on your cameras. We have a few minutes left. I would like to answer at least some of the questions that we are getting. As I already mentioned, we are going to be downloading all the questions and trying to answer as many as we can as a follow-up on this webinar. But one question that we actually got already before the webinar, I would like to actually ask Amy, what, if any, expectations should our audience sort of have when it comes to potential changes from the proposed to a final rule? And when do you think a realistic time frame is that this new rule will go into effect?
Well, I'm not going to say what a realistic time frame is. I'm going to say what's possible. I don't know. Nobody knows what's happening in the real world, least of all the people finalizing the rule. But if they really wanted to, they could certainly finalize this rule before the end of the calendar year. When the final rule is published, it will not be able to go into effect sooner than 60 days after it's in the Federal Register. I don't know. So that is very possible that we could see the final rule, within 3 months of the final comments being submitted. It's possible. And it could go into effect, in February or March of 2026. This is possible. I think that there's little doubt. And that's presuming that we don't have a way under the Administrative Procedure Act to get an injunction. All those court cases about injunctions and the Supreme Court saying you can't get injunctions don't have anything to do with injunctions under the Administrative Procedure Act. So if there is a cause of action under the APA, because we all submit comments saying this is very costly, here are 5 alternatives, and they say, thank you very much, we don't care, and they don't respond. They don't explain why they're rejecting those things. That it is costly, and that there are reasonable alternatives that have been suggested that they're not evaluating. If that's the case, then it could be possible to get an injunction. So I think that I am confident that, I'm confident that for whatever reason, this is a big priority of this administration. Early on, in early February, when some career folks who I know were still working in government, they were getting pressured then to hurry up and finish the duration of status rule. This was the top priority from the White House of we must have this. And one or more, maybe there's several people in the chat, in the Q&A, were talking about why is this such a priority? Aren't there other ways? And like Ravi was saying, can't some of this be done with SEVIS? So I think that the hope is, if we are able to come up with alternatives, that there are a fixed period of stay that's finalized, but on the back end, the extension of stay process is totally flexible. On the front end, there are longer periods of admission for J1 physicians that Sarah was talking about, research scholars. It's actually the teachers who get 3+2 K through 12 teachers, so they also need the longer period of stay, J1 teachers. But I think that it's possible that there could be changes. I think what we expect is that they're not going to very carefully consider all of the costliness problems that we identify and all of the alternatives we identify. The reason why we're talking about costs and alternatives is that we want to be able to go to a judge to say the agency has acted arbitrarily and capriciously, and they can do this, but they need to do it in a way that is not so costly and not so cumbersome. So I think it's very unlikely that we are going to see a long delay, like, sometimes comment periods close and a year later we get a final rule. I don't think that's going to happen. And I think it's possible that they could have some revisions in the rule. To be honest, I think I believe that they are very serious about wanting to have a fixed period of stay for all students and exchange visitors. And if they really want that, they should make changes to the actual implementation and extension of stay process and other specifics that they identify, which are very cumbersome, because they're unreasonable. So if they actually want that outcome, they should make changes, but we shall see. Okay, back to you.
Thank you so much, Amy. I really appreciate that response. Unfortunately, we are running out of time so fast. This is such a complex topic. There is so much to cover, and our audience today had such great questions. So as I said before, we're going to download them. We're going to try to answer as many as we can and share with you all as a follow-up. I want to thank you, everyone. I want to thank you, our speakers. I want to thank you, our audience. Thank you for being here. Please do not forget to comment. This is really, really important. Reach out to us with any questions. Customize your comments as much as possible. And we are very much looking forward to seeing you next time. Have a great rest of your day. Thank you so much.
Thank you.